Congress may permit courts of law to appoint some inferior officers, but Congress may not do so in a way that is incongruous with appointers' judicial duties or which interferes with the executive. We've got separation of powers that need to be respected. Now, their position from Comey and Letish would take us into a constitutional disaster. It would allow Article 3 courts to control the appointment of an executive official even over the president's objection, if they got their way. On their view, once the 120-day clock has run out, only the courts can appoint a new attorney until somebody is Senate confirmed. The president, of course, remains free to remove whomever the court selects, but that arrangement raises the possibility that the courts repeatedly could continue making appointments unacceptable to the president, and the president could continue removing those people until the court picks someone that he likes. Now, that regime is profoundly destabilizing than the one where the attorney general and the district court make simultaneous picks and the attorney general's pick prevails. Lots more, we're working together. Courts should strive to avoid, not embrace, these interbranch conflicts. This raises serious separation of powers issues. Now, this case illustrates the dangers right here. Presumably because the previous interim U.S. attorney was appointed by the Eastern District, those judges on their own, sua sponte, transferred the present motions to this court. Other courts have felt compelled to transfer similar cases, and courts should avoid an interpretation that would routinely put themselves in an uncomfortable position. You're not supposed to be in the middle of the conflict. Instead, consistent with the Constitution and the Appointments Clause and the separation of powers, Congress gave the courts only a narrow but important role of making the seat filled when political branches ultimately fail to act. And they haven't done that now.